October 17 meeting, 1991, of the Sacramento City County Cable Commission. This meeting of the Sacramento Metropolitan Cable Television Commission is being videotaped in its entirety and will be cablecast without interruption on Metro Cable 61, the government affairs channel on the Sacramento cable system. Today's meeting is being cablecast live and will be repeated Friday at 9 a.m. Members of the audience wishing to address the commission should fill out a speaker identification form located at the back table and give it to the secretary. When you address us, please speak into the microphone, adjusting it to your height, and state your name for the record. One other comment this day: when we begin the hearing under item number 1 on our agenda, there will be no participation from the audience except when called as a witness or when being an interrogator for the witnesses themselves, so that your opportunity to appear this afternoon as a person who wishes to speak to the commission would be under item number 2, public opportunity to discuss matters not on this agenda but within commission jurisdiction. Please call the roll.
Catlin Johnson. Toby Johnson. Collins.
Here.
Roby.
Here.
Strang.
Here.
Harris. Stana.
Here.
Renee.
Here.
Fletcher.
Here. There is a quorum present. Some comments from the chairman. This meeting was called to enforce the duly adopted regulations of the Sacramento Metropolitan Cable Television Commission. The official purpose of the enforcement hearing will be to decide if SCT has broken the rules of this body and in what manner they should be sanctioned. This meeting has another purpose. I desire to send a message to SCT, its corporate leaders, and its managers. I believe the company has insulted this commission repeatedly and openly, and we want to declare that today. I would prefer our role to be one of a wise old aunt or uncle, guiding and advising, and when warranted, to look a niece or a nephew in the eye and say, "You are acting irresponsibly." And because the uncle or aunt is respected, the niece or nephew listens until there is understanding. SCT's actions over the past year are forcing us as a commission into a much different role. In order to protect our public, we have invented regulations. These regulations are a reflection of the thousands of complaints received by the commission in the past. They have been translated into procedures which will solve customer problems, and they will make money for Sacramento Cable. That's what satisfied customers do. In the course of the last several weeks, I've seen to it that each member of the board was kept informed of the daily events and my decisions. I have relied greatly upon our staff, but being the fundamentalist that I am, I refuse to allow SCT to engage us in negotiations over our regulations. First, I had no authority to do so. Second, because Sacramento Cable has refused to acknowledge our authority and repeatedly, as you will see, refused, neglected, or failed to comply, there is no reason to negotiate. I directed Brent Blair to advise the SCT attorney that SCT would have an opportunity to present its case for negotiations at today's meeting. Therefore, I request a motion from the floor to amend the agenda, giving SCT 10 minutes to address the commission. At the conclusion of the 10 minutes, I will open the enforcement hearing and direct our counsel to summarize the procedures to be employed and begin the presentation of evidence. This concludes my opening comments, and we now welcome to the microphone a representative of Sacramento Cable who will state his name and
the motion,
then...
Mr. Chair.
Motion.
Mr. Chair, I'll make the motion that we...
Thank you. I got ahead of myself by one paragraph. The motion has been made to allow a 10-minute presentation ahead of our own agenda item. All those in favor will say aye after we second it. Those in favor say aye. Aye. Opposed? Is so ordered, and thank you for covering my blunders so very well. Mr. Moore, are you representing Sacramento Cable at this point? Mr. Moorhead?
Yes, Mr. Rupert has a couple of comments before I speak.
My name is Kim Ruckert. I'm the General Manager of Sacramento Cable. Thank you, Mr. Chairman and Commission. Back in December of 1990, when I came to Sacramento Cable, we have made, in that period of time between now and September, quantum leaps in customer service, and I think that is presented in many of our documentation that we have provided to you throughout the past 9 months. Since March, we have been evaluating the regulations that were adopted. And we have had these evaluations have been done, and the discussions were initiated so that we could attempt to reach some sort of either clear understanding or at least a working understanding of the regulations. My fear is that there's a misunderstanding on our position. We have had another proposal that we have made many proposals to the Commission, and as of today, we have made another proposal to the Commission, which addresses many, if not all, of the issues that are of concern. I think that not only do these reach those concerns, but also are probably going to be helpful in preventing, or at least hopefully will help us reach some sort of an enforcement that we can live within and that we can work within. And we certainly want to cooperate with this Cable Commission in obtaining a form of regulations that we can not only live with but can operate under, so that the customers are better served. And ultimately, as I've stated on many occasions, that is our ultimate concern. One, let's take care of the customers. We do want to take care of the customers. We want to give good customer service. But by the same token, we want to be able to make sure that we can live within the regulations that have been adopted by this Commission. With this, I would like to have John Moorhead address the Commission on our current proposal and maybe give a little background. Thank you.
Thank you, Kim. Mr. Chairman, members of the Commission, I just want to reiterate what Kim said. Since August, late in August, I think there has been some considerable confusion over the position of my client. We met in August, it's either the 23rd or the 25th, with Director Esposito and Mr. Blair. The purpose of that meeting, from which we came away extremely optimistic, was to have a discussion concerning the substance of the regulations, their verbiage, their impact, and to air out some of our concerns over them. It was not to fight over whether we are bound by them or not bound by them. Mr. Blair and I can do that as lawyers quite adequately. We came away from that meeting, and our understanding was that discussions would proceed no further until we had made a proposal with regard to implementation of any agreement that could come out of substantive discussions, be it with the director, the chairman, or the full commission. Such proposal was made in my letter of September 25th, in which, and I have read it many times since controversy has arisen, it says, if we can come to an agreement on substance in the regulations, and we have many areas that we do want to discuss with you about the impact of the regulations in terms of the ability of this company or any other cable company to comply with them without spending millions and millions of dollars. But if we could come to agreement on interpretation and clarification, that we would propose an implementation device by which we would be bound by them. And I did that in my letter of September 25th, which I hope you all have. At the end of that letter, and I can't remember if it was point E and F or point F and G, I suggested that if the company complied with those regulations for 5 years, that the regulations would go away. I suggested to Mr. Blair in my letter that this would be some form of sunset provision. It's not a concept that is foreign to regulatory bodies, and that there would be no further regulation. Our legal position in this matter, I think there's no mistake about. We, as a legal matter, have a very good faith position, in all good faith to us, that these regulations were not contemplated and were beyond the scope of this Commission's powers. The Commission, Mr. Blair and Mr. Esposito, have a different position. I believe, and I suggest that it is foolhardy for us to get involved, my client vis-a-vis the Commission, over that conceptual issue if we can truly come to terms on what pragmatically these regulations should be. I encourage you to treat our position, our legal position, as tendered in all good faith. I have trouble believing that each of you don't know that this is an issue of controversy throughout the country. It's an issue in Congress, and it's going to be litigated by all kinds of cable companies and regulatory bodies, each of them thinking they have a position. I have suggested in now 2 letters, and Mr. Champagne in a 3rd letter delivered to Mr. Fletcher today, we want to avoid that. If we had wanted to file suit, we could have done it in March or April or May or June or July or August or September or up until yesterday in the face of these hearings. My 2nd letter, written October 14th, after some confusion had arisen, states again, if we can come to agreement on interpretation, clarification, terms, we will agree to be bound. We were not going to fight over the ephemeral and hypothetical issue of regulation in general. Today, after discussions between Mr. Esposito and Mr. Champagne, whose name I assume you know, we have another proposal. We keep making the proposals. We keep saying, please believe us. We want to have a forum, a work session, however you want to do it, to talk about each of the regs, how they impact, and including the disclosure issue that we may or may not deal with on the agenda item a little bit later. I will tell you that the disclosure issue, as it spawned itself and created controversy in August with the notice of rate increase, part of the problems involved that, I think, in all candor, involved some misunderstanding about what was going on in this preliminary meeting in August. Disclosure would have been different, and we can deal with that later. In any event, Chairman Fletcher has before him another proposal today. And it suggests if we can come to agreement on substance in the regs, we will agree to be bound. It states that a new disclosure will be given in cooperation with Mr. Esposito, who's already, for the most part, already crafted. It states that we will waive downgrade fees for not 30 days, 60 days, but 90 days from the date of the initial notice. It has a standstill period in order to allow us to calmly and rationally deal with each of the regulations. And I can assure you that it will take days. And if you really want to learn about the regs and how they impact this business and how they impact your constituency, sometimes in ways that we believe are not necessarily what you intended, that we can meet in the middle and come up with something that will make sense. And we encourage you to do that. In our letter, I have copies, Mr. Chairman, if you want to have copies for everyone. I'd be happy to disseminate those.
Please obtain copies and distribute them.
It's going to be tough to do this in 10 minutes with the letter, but if I can just have back, let me get the phone. I think I'll keep speaking while she passes those out, if that's all right, because I'm now down to 52 seconds.
52 seconds.
And if we're going to hold fast to that and move right on as a preordained matter, then I guess we'll do that. We have suggested, and all of this is without waiver of our ultimate legal position if no agreement is reached, that we'd like to set a timetable and have everything resolved by December 5th or not resolved, and that there would be a standstill during that period on enforcement. On the issue of the remote controls, which we can talk about, and we're happy to talk about the converter and remote control issue. There would be rebates retroactive to September 1st for anybody that wants to downgrade from their remote during the period specified in my letter. In Mr. Champagne's letter, he has indicated his willingness to consent to some form of consensual fine. The amount as suggested has been $60,000, and we would like, if my presentation in this letter has whetted your appetite at all for rational discussion, which we, in all candor, have been requesting for quite some time now. You can treat it as 11th hour if you wish. It is not. This is a difficult and controversial problem. I invite you to discuss with us today, in some fashion, our proposals. There have now been 3 of them. And set...
Mr. Moore, your time has expired.
I would make a motion, and I would request that I have an additional 5 minutes to at least put this matter before.
We granted you 10 minutes.
And I'm simply requesting more.
What is the pleasure of the group? Those in favor of granting another 5 minutes, say aye. 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 Those opposed? It is granted.
Thank you very much, Mr. Chairman and members of the Commission. I speak fast enough when I'm speaking normally, and I hope it doesn't get garbled. I encourage you to read this letter in conjunction with the prior letters sent. Give us a little bit of the benefit of the doubt. Perhaps every word that we speak as human beings or write and write down on paper is not necessarily always the correct one. We have sent a message that we want to come up with a program by which we can be bound. We're not talking about customer service guidelines, which were talked about by my client to you prior to your adoption of the regulations. We're talking about being bound by regulations. If, in fact, we go forward with the enforcement hearing in the face of our attempts to come to an overall solution to this issue, which again I suggest is controversial. It's controversial nationally. I don't think any of us should put our heads in the sand. Then we can get on and let Mr. Ruckert, as the new manager, continue to make the strides that he's made. And there have been considerable pragmatic strides on the telephone response side, on the installation side, etc., etc. Those are important things. The company wants to deal with it. I would ask you to treat us as appearing here in all good faith on this issue. And let's not all paint ourselves into conceptual corners where we all have to come out fighting. We don't want to do that. There's been enough of that in Sacramento. SCT knows that. I know that. And I hope you know that. One of the provisions in Mr. Champagne's letter is that you won't change the regulations once there's a format that's clarified and agreed to. And in return for that, we won't contest the regulations under the theories that I'm sure you've discussed with Mr. Blair, federal preemption, procedural presumption, and whatnot. That we reserve the right to contest the regulations after we would have had these discussions and come up with agreements. We would reserve the right to contest them if you unilaterally in the future change them again. If we did it by agreement, no problem. I would suggest that the 2 primary issues for discussion, if this honorable body would like to discuss that with us today, would be point 1 on the amount of consensual fine, which would have to be entered into without admission on our part, and the issue of how do we go about giving us our certainty versus a reaffirmation, if you will, whatever you want to call it, of your regulatory power. I would request, with all due respect, and I hope I'm not out of order, that you inquire of Mr. Blair with regard to his views on the reasonableness of our crafting of the proposal as it relates to the future right to contest if you unilaterally change. Mr. Blair and I, as attorneys, have discussed this concept, and it's been a difficult one in terms of a mechanism to protect both sides. I'll stand down 2 minutes early for my extended 5 minutes. I'll entertain questions. The only other thing I want to say is there's been difficult moments between SCT from time to time. Remember, there's other cable companies here now that are subject to these regulations. And I've been involved in some of those. I wasn't here at the beginning. We've resolved them over and over again to everybody's satisfaction. And the torch I'm carrying today is to get this resolved and get you folks in a position where you can sit down and really, really learn about that. How does our billing work? How does disconnect work? Et cetera, et cetera. And then let's assess how to do fair things for the customers and the company, not with the scepter of this issue on disclosure and a $60,000 fine hanging over us. I suggest that that is a potential impediment to trying very quickly in the next 45 to 50 days to get an overall resolution. Thank you for your patience.
Mr. Moorhead, we appreciate this letter. Naturally, we have not had time to digest it or consider it, but due consideration will be given. Be in touch with you. Are you the appropriate one that we would be in touch with first?
This last letter is from Mr. Champagne. It all depends, Mr. Chairman, on what lines of communication we decide to set up.
Well,
that's been part of the problem.
I want you to name one person to whom we communicate. If they spread it to others, excellently, but
communicate
we need
with me.
One person.
That would be fine.
You or Kim or Campaign, whatever.
I prefer, in all candor, because I think there were a lot of legalities in this, to have Mr. Blair communicate with me.
Well, I'm talking about cable communication, cable commission communications. You would prefer they go to you, right?
I'd prefer
for the immediate future. Will.
In the immediate future, they should come to me.
All right. We'll have a respect for that. Thank you.
Thank you.
We now move to the enforcement hearing. From this point on, it is a formal process, and I'm going to ask our legal counsel, Brent Blair, to make his presentation and to describe how it is going to operate.
Thank you, Mr. Chairman and members. Although we've had many meetings and many hearings of various types at the Cable Commission over the years, we've never before had a hearing of this nature. So I want to take a couple of moments and tell you a little bit about it. Our ordinance sets up alternative ways of handling enforcement hearings, and one of them is to take the matter to an administrative law judge who would report to the Commission after taking evidence. That is not what we're doing here today. Today, the Commission will be sitting as administrative judges, if you will, of the facts that will be presented. That's the reason, as the Chairman has indicated, that public testimony will not be admitted during this hearing. This is an evidentiary hearing in which you will hear testimony given under oath. And I've been informed by Mr. Moorhead that he will call several witnesses in his portion of presentation of the case. We will have but one on behalf of the Commission staff. Let me explain very briefly the process. We will begin by taking evidence from the standpoint of the Commission staff, because it is the burden on the Commission side to establish that there has been a violation of the regulations. Our witness will be Mr. Espasto. The Chairman will swear him to tell the truth. He will then give, because we've had the opportunity to prepare his testimony in advance, and I think it will go more quickly, a narrative statement that perhaps will run 10 minutes that will be evidentiary in nature. It will form the basis for what we will be asking you to do at the close of the hearing. After the completion of that, I don't anticipate any clarifying questions necessary from me. At that point, Mr. Moorhead will be afforded the opportunity to cross-examine Mr. Espasto. Our ordinance provides, as well as, of course, due process provides, that both parties to a hearing of this nature have the right to examine and cross-examine witnesses. This is an important right and ought not to be abridged. So if I have no idea how long this will take, if it cannot be concluded today, I would strongly recommend that we provide further opportunity at some other time. I say this while the rules of evidence, the formal rules of evidence that would be applied in a court of law do not apply here, and there is latitude within the chair and the commission to control the flow of evidence coming to you, I would strongly encourage you to allow full and fair cross-examination of witnesses. After Mr. Moorhead is completed, then it will be an opportunity for you as members of the commission to ask any questions. However, if you do ask any questions, it would be the rough equivalent of a judge asking questions, and so then both lawyers will have a chance to go back and ask additional questions. The important thing is, from the standpoint of our witnesses, Mr. Moorhead, our witness, Mr. Moorhead will have the last question. So if you ask questions, there will be another round of questions. Mr. Moorhead will have the last opportunity to cross-examine. At that point, we will rest our case. We will move to Mr. Moorhead's case on behalf of the franchisee. And please keep in mind, while we use the phrase SCT to refer to the local cable franchisee, it's really four entities, the most important and significant of which is now and always has been Scripps Howard Broadcasting Company. They're represented here by Mr. Moorhead as fully and completely as the small entity known as SCT. So if, in fact, I should slip at any time and cease to refer to the initial franchisee and call it SCT, I certainly intend to refer to all four entities which are jointly and severally bound to your commission to the performance of their obligations. At that point, Mr. Moorhead will present evidence. He may present evidence, he may not. It is his choice on behalf of his client, the franchisee. If he does, I will have the opportunity to cross-examine those witnesses upon the completion of his eliciting testimony. Then again, you will have the opportunity to ask questions, but if you do, we will full circuit again through the lawyers after those questions are completed, just as if a judge were to ask questions in the courtroom.
Mr. Blair? Mr. Chairman, if I may interrupt momentarily. Before becoming your sworn witness and in this space as your executive director, the letter put before me minutes ago addresses some issues that have been in my mind for several days now. I haven't had a chance to read this or evaluate it completely. I would like that opportunity possibly to expedite the proceedings we have before us. I'd like to meet with Brent briefly. I have a couple of questions I'd like him to ask Mr. Moorhead, which may be able to expedite our proceedings this afternoon. Specifically, my testimony could take quite some time. It addresses the history and the events of the last 6 or 7 months. Maybe we can get that in and move this quicker. With your permission, could we have 5 minutes?
You mean for us to hold a recess for 5 minutes?
Please.
Let's have a recess.
Please.
Have a 10-minute recess.
Satisfying?
Thank you very much.
I'll take that. We're going to take that.
Next recommendation, a change in my recommendation to incorporate some feelings and actions that I've had. I've been through these negotiations, these type of negotiations, and really these haven't been negotiations because we've been adamant that the purpose here was to discuss compliance with the customer service regulations. The process I'm very familiar with. Late last week, as these things evolved, as I began thinking of opportunity or ways to make all this come together. The letter that was put before us minutes ago addresses most of those issues. The overall objective in what we're doing, the goal is to improve customer service. We also have needed to get Sacramento Cable's attention. The Commission's duly adopted regulations, as the Chair said earlier, have been ignored, neglected, refused, as we have stated. That is a fact, that is real, that has benefited Sacramento Cable Television and hurt consumers. We cannot let that go without action, without sanction. To expedite these proceedings and bring this to a capsule, to encapsulate this now, I'd like to recommend, or I'm going to recommend for your consideration at this time, imposition of the fine as described in the resolution before you now, and incorporation thereof of the components of Mr. Moorhead's letter, with the proviso that the evidence that otherwise would have been presented, believe me, your attorney and myself and our staff have prepared and have ready at length all that's needed to go through a complete regulatory hearing. We're moving quickly. I can phrase that. We can go back through it again. There's two things that need to be addressed. One is conceding that the evidence goes on the record as far as the factual occurrences. And an issue that I want Brent to address relative to the longer-term regulatory enforceability of the Commission. It's an issue that we go back and forth on, but it has to do with legal rights and the last point of Mr. Moorhead's letter.
Okay. Now, I opened this hearing by presenting it to Mr. Blair. We allowed this side set of comments to intervene, but I'm going to rule that this letter is not up for consideration at this time. It certainly must have elements of goodness related to your remarks, but it is not the scheduled event on the program right now. Mr. Blair, this is your meeting, and you can respond to him or carry forward with the hearing. But I am going to say this letter has been received. It will be filed. It will be acted upon in due course. And I will seek the approval of the Commission at a later moment on how to handle that. But it is your hearing, Mr. Blair.
Well, Mr. Chairman, I'm your servant. I'll do whatever you want me to do. You've received a settlement proposal, and as I understood your director's comments, he's prepared to recommend with certain changes that settlement proposal that would obviate the hearing. If you want me to proceed with the hearing at this point, I'll do that. I'll do it any way you want me to do it. I just need some guidance as to what you want.
Could I ask procedurally?
My question was procedural. We could put this letter with the evidence that you're going to give, or we're going to give in a hearing, and do that as an agreement. Is that what you're saying?
Well, the hearing that we're about to enter upon is a quasi judicial hearing, and so what this is a proposal from the franchisee to settle that dispute without the necessity of proceeding further with the hearing, and without the necessity of coming to factual determinations. It has certain conditions. Your directors now inform me after some discussions outside that he is prepared to recommend these with certain modifications, and my understanding is that from Mr. Moorhead that he in turn is prepared to modify his letter to the extent necessary to meet the director's concerns. Now that is within your control or without it. You can suspend the hearing at this time and take the matter up because it has been added to your agenda, or you can proceed with the hearing as you wish. It is within your discretion to go either way.
Okay, I'd like to ask the question procedurally. If we were to direct to suspend right now a proceeding to direct that our chair also confer with the director. With
You can do anything you want to
Mr.
do, ma'am.
Moorhead, so that we are clear on how we want to proceed.
I want to be clear that there's nothing wrong. We don't have to do any of this anywhere but on the record if you want. I don't want to do it in the middle of technically the hearing. I want to
don't
suspend
either,
the
and that's
hearing.
why these are these procedural questions. We should really suspend the hearing
Yes.
and get into some of this other
If we're going to
discussion.
discuss a settlement proposal, we ought not to do it in the middle of the hearing that's trying to decide the underlying facts.
I agree. I want to get that away from the hearing.
But I do think I have to tell you that your director and Mr. Moorhead are proposing the same solution at this point. You may still, of course, feel free to reject it, but you may want to hear it in some format. I'm glad to go ahead. I am not an uncertain trumpet on this.
I feel myself, members of the audience, members of the commission, that we have assembled evidence that is irrefutable in my judgment. We have set up a program of events for this afternoon. Procedurally, we are at our strongest by going ahead with the plan that we evolved. Now, if you have an overriding reason, it has to be more than this letter, because this letter in item 7 says the commission shall agree to a moratorium of the current regulations during the period October 17 to December 5th of this year. That's today. We could, if we accept this letter as our guide, you have no regulations in effect from that moment on.
Well, that's why I'm suggesting we suspend these proceedings, that we ask for another about 10 minutes, and I would like to have the chair, who has represented this commission extremely ably in any of the conversations that have taken part, to have an opportunity to discuss this, and I would so move.
I would second that, and I would like to just add that I'd like to have about 3 minutes with the chair. Maybe we could, I'd like to have a couple of questions which I would like to have answers to for our chair to ask. But I think that I'd feel more comfortable with that.
But if we could take a motion first on suspending.
The motion is to
Just
suspend
suspend the
proceedings for 20 minutes?
Yeah.
Yeah, for about 20 minutes.
Is there a second to that
There's a
motion?
second to that.
All right, will the clerk call the roll on this vote, please?
Chapman Johnson. Toby Johnson. Collins.
Yes.
Roby.
Aye.
Strang.
Aye.
Harris. Costanza.
Aye.
Nay.
Aye.
Fletcher.
Aye.
Carried.
In terms of this hearing being suspended, the hearing is suspended. I think now is the opportunity for some board members to express any reservations they have before the chair goes into this meeting. I think Orville certainly talked about his reaction to the letter. We've only seen it for a short time. I see major problems in it, and some of which he has already articulated. I would hope that when you come back, you can address some of those. The obviously underlying motivation is that we believe it is our ability as a commission to have customer service regulations. We agree that those regulations should be adopted in duly noticed public hearings, which we had for the current regulations. This franchisee, as well as anyone else, had an opportunity to come in and address those regulations at that time. I have a real problem as an elected official saying we negotiate behind closed doors regulations that affect our consumers, and I want to state that as a real concern on the record. That we have a responsibility to our constituents to make sure that we act on their behalf. I cannot imagine a clearer case than a public disclosure that are in our regulations that deal with the simplest things, disclosing what's in the rate schedule, disclosing what's in those different limited basic and basic service regulations. They have a basic commitment, I believe, that they should keep in this community to provide full disclosure to people. That's not only in our regulations, I would think it would be a good and honest business practice. And I am really upset if we try to sell out our rights as a commission to represent our constituents. So I express that as a reservation, even in this suspended time while Orville meets with them. And that's how the letter affected me.
Well,
It's giving, you read, and I hope that it can be widely distributed as far as I'm concerned, what's in there.
I'm glad that Isla said exactly what was kind of on my mind. I am very uncomfortable up here with people walking outside and making some negotiations that I am no part of, from something that I just sat here and read, and I'm willing to talk about it, but this process is making me feel very uncomfortable. And I can talk with Orville. I have a few questions. He can certainly answer them. I have a great deal of faith in his ability. So we'll do that, and then we'll come back and see.
We might want to come back and just go over the letter, but outside the confines of any type of regulatory hearing.
Mr. Moorhead, do you have any objection to our proceeding in this manner at this moment?
No, Mr. Chairman, I welcome a full discussion in work session, in public session, of where we're really trying to go here to assuage matters such as terms such as sellout. Absolutely.
To that room for a little.
Mr. Chair, I might suggest that we're not in a formal evidentiary hearing right now. We're in our public hearing.
That's right.
I think it might be advisable for all the members of the commission to ask any questions that they might have in our public hearing right now. And we can get from the director and from SCP anything that they have. I think it might be more advisable than trying to do something else.
All right.
I really think we should do it in public and listen to hear what the sides have. There are some things that are very acceptable. They meet our objectives, in fact, in this letter. And I'm sure that we can scratch out those things that don't meet our objectives.
May I say one thing about this letter? It is advisory. It is interesting. It also contains things that we have talked about and could not accept. I don't wish us to get off onto consideration of this letter and its contents today, because it will ruin the hearing. It will suspend the process. It will deny the purpose for which we came together today, namely to assess damages. And when we meet 2 to 3 weeks from now, whatever, I will predict you'll be no farther ahead in the resolution of this. I talked with the signer of this letter less than 24 hours ago, who told me he would not accept or be bound by our regulations. And number 5, if agreement is reached by December 5 of 91, SAC Cable will agree to be bound by the agreed upon regulations indefinitely. If they don't agree upon them, which they haven't already, and continue, and I have the word of the signer of this letter that was that man's attitude, and he happens to be the one who has the final word on it. These gentlemen who have spoken today have their place, but they don't have the final word. The one who signed this letter does. And if he doesn't agree to those regs by December 5th, we're right back where we started. And yesterday he told me he would not agree to be bound by our regulation. Now that is a very persuasive idea in my mind, to say, consider this letter at its appropriate time, which I'd say is after this meeting is over.
I'd like to hear from our executive director and see what our staff has to say. Mr. Director?
Or break. Was there a motion to
Suspend the formal hearing.
We're suspended the formal hearing.
20 minutes.
For 20 minutes, and I think we need to do that first. The motion has been made, seconded, and passed. And I would like to go forward with that motion.
I don't have any question. I don't know. We've already done that. My problem is to do the rest in public as we should.
And we will come back and do that.
I think we are going.
Executive director.
I believe we will do that and do that in public. I indicated that I do believe that Orville has done a yeoman's job in representing us this far. I would like to give him that opportunity to meet now with our executive director and with Mr. Blair.
I would too.
And then we'll come back and proceed, either in the hearing or in just some sort of public session.
The one thing about this letter, I think it has value, and we can determine the value sitting around the table, but not in public, but we'll bring the unresolved portions back to this group for affirmation or denial, whatever. But I do know this, that today's item on the agenda, members of the commission, deals with the past, violations of the past. And this deals with the future, except they want us to declare a moratorium here of our regulations. That moratorium serves no valid purpose for us. I don't want to get in the merits of it, but I'm just citing that as an instance of how confusing you can become, and we can, by this letter, lose sight of the purpose that brought us together today. That purpose needs to be served so that our public knows without equivocation or doubt that we're sitting here representing perhaps up to 400,000 cable clients eventually, certainly 200,000 now, and that we mean to do something about it, and with the help of Sacramento Cable itself, we shall do it, but we're not going to solve that part of it today. So when the meeting convenes again related to the hearing, bear in mind that if we suspend action today, we shall have lost it. We shall have lost it. Because this is the day.
So it would appear to me, Mr. Chairperson, if you meet with our council and our executive, and they find several of the items in the proposed letter from Sacramento Cable acceptable and several of them not acceptable, maybe we can solve everything now. And whether we do meet with Mr. Moorhead or whether Mr. Moorhead stands there and we go down one by one, which is acceptable to all of us and which is not acceptable to all of us in Sacramento Cable, I don't care, but it seems, I think there's a possibility, and I would agree with you, we don't want to give up the criteria that we already believe are part of our franchise. We don't want a moratorium.
We're still in a suspension of the proceedings. Anyone here on commission has the opportunity still to respond or to suggest a plan. This includes you gentlemen as well.
Let me be clear, Mr. Chairman, that I've been party to these discussions. First of all, I think we're talking about the beginning of what could well be a judicial process. So I accept Mr. Moorhead's representation that he does deal on behalf of his client and he has authority to do so. That's number one. Number two, it is not the position of your director that he's going to recommend a settlement of this on the basis of this letter alone. There are other factors that have been proposed that we would like an opportunity to present either to the commission in open session or to you, Mr. Chairman, apart from this, to see if in fact this makes sense. If in fact we can attain through an agreement what we would do in a process that I'm very happy to undertake, I think you ought to know about it in advance rather than after the fact. And that's why I wanted an opportunity to present this. I don't care whether I present it here or whether I present it in a meeting with you, Mr. Chairman, or with any combination. I'll do it any way you want to do it. I think we deserve, and I think this is what caused your director to interrupt me, we deserve to take this up before I put you through this process. The fact that you've never done it before in the 8 years we've been together should tell you this is an extraordinary proceeding. So before we do that, I think that it behooves the commission to at least hear this. You may well do as you've indicated and reject it and send us on our way, but I think you ought to hear it, and then you certainly can't contend we didn't tell you. I have an obligation as a lawyer to convey settlement proposals. This is one. I want to convey it somehow to someone.
Mr. Chairman,
I don't care who.
One of the reasons we have this ordinance was to get Sacramento Cable Television's attention. We've achieved that. we have their attention, and it's about time. I think that we have suspended the hearing. I think we ought to suspend it for the rest of the afternoon. We ought to convene in another week, after which time there's been an opportunity for these discussions to occur, and we can take a look at that settlement.
All right, there is a proposal to suspend. I would like to reserve the right to set the date on another occasion after conferring with all of our people on the commission and their complex schedules. I'm sure you would agree with that.
I would.
The suggestion which we could take to find a consensus here now would be to suspend these proceedings, and I would assume you're giving up no rights, you're making no promise.
No, that was only for the 20 minutes,
This
that
is
motion.
20 minutes.
For 20 minutes.
Yeah, and so,
Can you get it done in 20 minutes?
I
I
think
can get it
absolutely.
done in 30 seconds if I just get someone I can talk to.
Right.
I'll do it here. I can outline what the proposal is, and you can tell me whether you want to do it or not, and we can get on with the hearing today. We don't need a lot of time.
Mr. Blair, the chair recognizes you for that statement.
Yay.
All right, do it in 30 seconds, Blair.
Another 30-second clock.
All right, what follows is a settlement proposal as Mr. Moorhead has conveyed it to me, and I want to make this, choose my words carefully. So if you paraphrase them, you do so at your own peril. The franchisee, all four entities, are prepared to concede the factual basis that is before you today. That is three specific allegations. One, that they did not submit on or before June 7, 1991, their subscriber documents to the Commission. Two, that they did not submit their complaint resolution procedure prior to June 7, 1992. And three, that they did not, at least 30 days prior to the general rate increase of October 1, submit a prior approved, a disclosure document in conformity with your regulations, which had the previous approval of this Commission, to their subscribers. The important distinction here is they did send something, but they're willing to concede that factually they did not send something that had the prior approval of this Commission, because obviously this Commission has not previously approved such a document. They will concede that factual basis. However, the caveat is that it is a settlement. That is, that concession is not to be used and cannot be used by any third party against the franchisee, apart from this Commission. A further condition of the settlement is they will concede the reasonableness of a sanction of $59,200, which is the maximum, I will advise you, under law that you can impose today. As to the moratorium provision of the letter, the agreement that they would be proposing to enter into would indicate that your Commission would not further enforce remedies of your regulations for that period of time. That is to say, if the negotiations undertaken now for this approximately 6.5 to 7 week period should fail, you would be restored to the status quo ante. You could keep the money that was paid. It's a settlement payment. They don't get that money back if the negotiations fail. But we can't, by this agreement, impose additional sanctions for that 7 week period. Now, obviously, if they haven't done these things during that period of time, they're still in violation, and you would have the same rights that you have today to impose additional penalties from that point forward. There are two important factors here. One I've already mentioned. The second is that by entering into this agreement, the franchisee is not conceding its legal position as to our ability to impose these regulations in the first instance. I previously advised you in writing and orally in every way that I can communicate, I've already passed 30 seconds, that you do have that authority. You have done so, and I'll defend it, and I believe we will ultimately prevail in any contest. All we are agreeing to do with this proposal is not to contest it at this time. If we should contest it in the future, both sides would have the same arguments they would have if I go to court tomorrow. And so I think, fairly as to that issue, what's proposed, you lose nothing. Now, I'm not here to recommend that you do one thing or another. There is one difference from the resolution. The director said it a few moments ago. They're not going to concede that this fine keeps mounting from this day forward, and that's in that resolution. But as of today, they're willing to concede the amount of the imposition, which is the maximum amount that I can advise you to impose today. So that is the proposal. We would propose, your director would recommend, that I go back and put these into a resolution that does the things I've just told you, plus the other conditions that are set forth here regarding rebates on remote controls and so forth. That's the proposal they've made to us. There's nothing secretive about it. If you don't want to do it, I'm glad to proceed with the hearing. I'm not an uncertain trumpet.
And for consumers, the items mentioned in the letter, specifically an interim rate disclosure that staff can approve, goes out within 10 days, as well as complete waiver of fees for persons requesting the remote control disconnect, and also the extension of the banning of the downgrade fee to the end of November 30th.
Mr. Moorhead, has this been described word-wise and idea-wise in a way that you can agree to, or is there any deviation from what Mr. Blair has said?
Only one slight deviation, and it may only have been my misunderstanding what Mr. Blair said on the moratorium, and I'd like to speak to that. While we're in this negotiation phase, the true intent of the proposal is that we won't get fined for anything that happens during that period of time. We're prepared to make other representations to you about what we will and won't do during that period. But as we are going forward and attempting to come up with a grander disclosure scheme involving handbooks and all kinds of things we can talk about later, we don't want to get caught in the middle during that period. So I think that's a matter.
Substantiate what he has said.
Well, there was a rather key issue, though, and I think Mr. Blair, and I think had understood me before, and I think he just misstated it a touch.
Let me flesh out what we've said, and if it's not accurate, we'll get it straight. What was said was that during this period of time, the franchisee will take no actions that would be in contravention to those regulations, and we would agree not to impose any penalties for that period of time at any time in the future. And specifically, I asked Mr. Moorhead for the assurance and the agreement that there wouldn't be any more price increases during this time, so that we don't run the risk of having something awful done. But I think that was our understanding.
That's
was
correct.
It not?
You
All right.
both agree on that topic.
That's correct.
Okay, I have a question, Mr. Fletcher.
Surely.
Can we decrease the period of time? December 5th is too far away. I'd like to see this done sooner. I'd like to see that done in 30 days.
We can do that in the negotiation setting unless you can respond on that immediately today.
All I can say on the December 5th is that as a response to discussions we'd had with your director.
What I'm worried about...
That's your next regularly scheduled meeting.
Wait,
That's when it takes effect.
this gentleman has the floor, and then Mr. Moore has the response.
What I'm worried about is expanding the time so long that we're going to get into, we're going to lose our focus in terms of what we've got to do. And if staff get it done in 30 days, I'd like to see us. I'd support if we can get it done in 30 days. Rich, can you?
Yes, we can.
Okay. Mr. Moorhead, did you?
I have explained some of my personal professional problems involving a month-long trial that starts November 4th, and I'd like to get it done by October 30th. I'm not going to represent we can. This could be a whole body of new documents coming back. We will live with whatever the Honorable Commission tells us to do on this timetable. I'll stay here tonight and start working tonight with him. We've been willing to do that. Do whatever you say.
Of the Commission, you've heard this proposal, you've heard it verified, so that in essence the two legal eagles agree upon a scheme, a plan, a modus operandi that if it comes to a satisfactory conclusion, resolves for the immediate future the problems that both have faced from their point of view. Now, we have come to the end of our 20 minutes. We have a problem settled here, and that is and we'll put it either or. We either go for a hearing or we go for suspending this meeting, or we go perhaps for postponing this meeting to another date. Now, what's your pleasure? Let's talk about it for a moment. Yes.
The concern which I had that I think I wanted 20 minutes for, part of that has been answered. And I still am very uncomfortable with this process, and I'm somewhat critical. I'm sorry, but I'm very critical of what has passed here this afternoon. But my concern was, legally, where does this put us if we decide to go along with the suspension and the moratorium in the future? You know, we didn't get where we are today for no good reason. I mean, there was very good reason for us to be here. It's not something that we made up. Our goal, obviously, is to get this corrected because people are being hurt because of it on both sides. But if I understand what you've just said, this, whatever we decide to do here today, in no way actually affects the case on our ability in the future to actually, if we need to collect a fee until we can get this into place, so that by whatever action we take, it does not put us legally in less of a position of strength in order to get this straightened out.
It does not affect in any way our ability to enforce our regulations in the future after December 5, assuming no agreement. Even assuming no agreement, it does not affect in any way our legal position. Now, obviously, in a settlement, we are agreeing to accept $59,200 for the 3 wrongs that we have alleged, and they will concede, and we can't revisit those. But we certainly can, it does not affect in any way, and you've accurately stated that, our legal position as to any violations of our regulations after December 5.
And of course, I think the big piece of that is we are making a big decision today. Because in a way, what we're saying is that we are going to accept the 59.2 for those 3 past problems. And I think we need to be clear on that, because that is, frankly, a big step in my mind. And that's what I would think that Orville, I'd like to have you talk with staff about and be very clear when you come back to this commission of that your recommendation to us. You have done, I think, an excellent job.
Sure. Thank you.
May I be heard, Mr. Chairman? I'd just like to say one thing on this timing process, because December 5th came up again. We would try to live within the 30 days. It's recommended by Mr. Costanis.
We need most of the month of November, don't we? You have to trade off your ideas to the others who you work with.
Yes, and one of the
must do the same.
Yes,
and then we have to prepare this for no later than the December 5th.
That's correct. The December 5th, as we had discussed it, envisioned all drafting done and full resolutions crafted for presentation at that meeting. What I really was getting to is I really am inviting and very much want, during that period, early on, to have one work session, however you phrase it in your jurisdiction, with all of the commissioners, where we can all think out loud about these consumer matters as we go down. If you want to appoint a point person to do the negotiating, that's fine too. But I am suggesting that I think we would both all learn a lot about how this works as we go forward and are looking in the interpretations. But that's up to you. That's my suggestion.
I got a real problem with that. But let me ask a couple more questions, because that to me would negate public hearing on regulations if it was just a negotiating session on what we're going to agree or not agree to be bound by, because anything that we would come up with is not up totally just between the cable company and this board. The public is a part of this process. They are the consumers of your system, and they're our constituents and of any other franchisee in this or licensee in this area. So I would think that anything that we would have would be subjected to a public hearing in terms of regulations. We might have people in the public who would not agree with you or with us in terms of whether those are adequate consumer regulations.
Let there be no mistake, I'd be perfectly willing to have that work session in public on the record.
No, I understand that.
Where we can talk about how these work and how a disconnect works, on the record in public, so that then decisions can be made as to whether any of the positions we've taken pragmatically on each of these sections of the regulations have any merit. We'll do it in front of 10 more cameras than are here.
Yeah, we assumed that when we adopted them, we had a public hearing, and there was plenty of time during that public hearing for any of the licensees, the franchisee, and the public to come forward and testify. Am I to understand by what was said by Brent and you, Mr. Moorhead, that the rest of this letter is moot?
Yeah. Yes.
Okay.
I'm sorry, the rest of the letter is...
The rest of the letter is not now under discussion.
Well, it's not in dispute as far as your director's recommendation. He's prepared to recommend that.
Because there's parts of this that no changes other than agreement will occur for 2 years, etc. I can't accept that in terms of that's not reasonable, because you could have public hearings on regulations in the interim that would be changed, and the cable company might vehemently oppose in a public hearing, and still the board might adopt. And I would not want to be fettered by, in terms of a legitimate public hearing, by that. That's a concern. I assume that what's before us now is to either be willing to enter into this type of an approach towards a settlement, or to set a date if we wish to proceed forward, or proceed forward today with the hearing that's been called for and which has been temporarily suspended.
I am willing to, if we have this acknowledgement, if we do perform the finding of the 59,000 plus, if we do suspend these proceedings to an unnamed date if necessary to continue, and if we can have the agreement that I, as chairman, can appoint 1 or 2 additional people from the commission to aid us, I would go for that kind of a procedure. How we write it up for our minutes is something we'll have to consider.
So could we suspend this hearing today to a date certain in November then? Or,
I think we ought to continue.
You can't take their money and come back and have another hearing.
No, I understand that.
All right. This is a settlement of these allegations, so there's nothing more to continue. If you want that, you can do that. Otherwise, we can go ahead and do the hearing.
What do you do if negotiations break down? To find out there's no common ground.
If negotiations break down as of December 5, you're free to, again, if they are still in violation, you are right where you are today, except that you've agreed to take $59,200 for all violations that you've alleged prior to December 5. That's what you've agreed to do. Now, that's the effect of the settlement. It doesn't change your position to enforce them in the future. You're agreeing to take a sum certain for that now. I got to keep in mind here that in response to Mrs. Roby's comment a few minutes ago, that's the most you can impose today. You can't impose any more.
That's true. I think all we want to understand are I'll call them strings, and I don't really mean, that's the only term I can think of. We're trying to clarify the strings attached to that settlement.
That's right.
And weigh the risk to our constituents. If at some point we have to litigate on this question of power to regulate in the future, and that is the concern the Commission has. I do not see us conceding the power to regulate. No. I think we're saying that loud and clear. As to these offenses, they would be conceding the factual basis. We would be collecting the fine. The settlement cannot be used by any third party as a basis for their individual pursuit of the company. I assume that means.
That's right.
Okay. The moratorium simply meant that as to the period between now and December 5th, when we would be back in our next formal session, we would not be imposing fines during that period, and they would be abiding by the regulations during that time. So they're not going to raise rates or anything else during that period of time.
One other factor is...
I've made some other notes. But go ahead.
Go ahead.
No, you go ahead.
Well, the statement is we're not going to apply fines for that period, not in that period. In other words, we're not going to apply any fines on the 6th of December for the period prior to December 5, even though it's not within that period.
How do you know or not? We haven't agreed.
Well, sir, that's the proposal. When I say that, I'm just trying to outline the proposal. I'm not suggesting that you have to take this. You can tell them to go fish. The second aspect that's very important, and I want to be very clear on, is that they are not waiving, by entering into this, their legal positions any more than we are affecting our legal positions relative to the efficacy of these regulations after December 5.
And the only risk you run there is that in this particular case, you have a very excellent case of them not applying.
Yes.
In the future, they might choose less obscure or less obvious ones, and it would be a little more difficult for this commission to say, these are the facts we want to take forward.
From the lawyer standpoint, that's absolutely correct. We have a stone cold case here. And
the other thing I want to talk about, though, in relationship, because I didn't hear it brought up at all, they suggest in the very opening paragraph that we cannot use this fine to give any publicity concerning the consumer regulations. That was not a part of your presentation, but I also understood you to say we're not bound by that.
Well,
but they are going to provide the full disclosure. Is that correct?
That's correct. They will provide the interim disclosure in a form suitable to staff.
My understanding of this wording was that it referred to the proposed media campaign that Mr. Espasto had later to discuss on.
Yeah, well, that's very true. If they refuse to disclose, I think we have a duty to our constituents.
But you're only bound not to do it if they do within 10 days what they've said they'll do.
I just had one last quick thing or a pilot.
Okay, at least I think I understand the proposal now.
Anything from this side?
The only thing I'm bothered with is still the timeline. I don't know that they need until December 5th. I'd like to see it done by, are we going to meet on November 7th or not?
There's no scheduled meeting until December 5th.
I would like to keep everyone's feet to the fire to get it done by the November 7th period. That way we can...
Your exposure time is a lot less by November 7th.
I can tell you how this will move very rapidly. This has been heard by the gentleman out front before. If they acknowledge our enforceability and acknowledge that we have regulations which have merit, we can move fast. But the thing we've got hung up on behind the scenes is a failure on their part to acknowledge that we exist. And on more than one occasion, Mr. Ruckert in this very room said, we're not going to follow your regulations. We don't have to. Now that has to change. It has to change so diametrically that it's opposite to what has been said, or we will get nowhere in the negotiation. You have to
that is the bottom line.
Acknowledge our capability of producing regulations for the benefit of the people we represent. You don't have to in one way. You can contest it all the way, but there's no use of talking about the content of regulations if you don't acknowledge our ability to enforce them. And we refused recently to talk about the substance of regulations because there was no word from the other side of the table related to acknowledging we had any enforceability. Now, that, I want to tell you, is the hinge of 90% of this.
Let me make very clear, Mr. Chairman, that is true, and I think the important point that I may not have mentioned, and I want to mention, and I want to make sure I have Mr. Moorhead's clear statement on this. My understanding of this proposal, as it is indicated here, is that as to the regulations, if out of this process should come agreeable regulations, Sacramento Cable, forget Sacramento Cable, the initial franchisee will agree to abide by those regulations infinitely, ad infinitum. forever, I think, was Mr. Champagne's term this morning on the phone. That means it is not limited by time. It's not going to go away. We're not going to deny that. They're going to agree to that if, in fact, they come to agreement on the substance of the regulations. That's the sticking point that the chair has so carefully stated that has prevented us from ever having this before. And I know there's been criticism of the process, but quite frankly, we're not in control of when these folks say they're going to change their position. And they have changed their position on that precise point very, very significantly today. And before that, that was not the case. So I think that that should be clear. Mr. Moorhead, that is your proposal, is it not?
It is, but I want to take issue with as if this concept just evolved today. We said that in August, and I've said it in my prior 2 letters, and I've said it here. There's been a lot, again, I said in my opening statement, each of my letters says what it says. So what Mr. Blair says in terms of where we are right now, that is true. It's also where we have been at some time in the past.
I just had one more thing, Mr. Chair, if I can ask one more question. In my mind, the rest of what our chair has just stated, in my mind, the fact that Stack Cable has said that they will pay the fee for those last 3 discrepancies, they admit that there have been these problems. I mean, in a way, in my mind, they are now admitting that they have not complied with the regulations. And I think, at least that's the way I interpret that. They also are saying, in a way, that we want a clean slate, that we will go forward from that clean slate to develop those regulations. But I think they've admitted that there have been problems. Now, if I'm wrong, I mean, I don't have the legal jargon, but we're in strings and clean slates here, but I do think that is what is being said here today.
My understanding of this proposal, Mrs. Roby, is that is exactly what's being said. There will be a clear, factual concession, and I understand that to be the proposal, that they did, in fact, fail to do these 3 things that have been alleged, and that obviates the necessity for proceeding with the hearing in order to prove what they're conceding. And I understand that to be a clear concession. The only caveat to that, as I understand it, it's not material to this commission, is that no one else can use it, which they could use if it were established in some other forum, perhaps. But as to the gravamen of whether or not they're admitting they didn't do these things, I think that's clear. Is that clear, Mr. Moorhead?
Seems clear to me, Mr.
All right,
Blair.
thank you.
And you two gentlemen are confident that this is the way to proceed at this point?
That's a policy question.
Yes. Mr. Chairman, this is a settlement proposal with a few of the strings, as have been mentioned, adjusted as we have. I believe this is as good as we can get from this company right now today. You have imposed, or will impose if you approve this, the maximum penalty your regulations provide. You have established a short time frame with which to do what should have been done before, which is to discuss and interpret and understand the regulations as we have adopted them. And you are providing to consumers an immediate increase in the information and choices they have about their cable television service. And you're giving up nothing. I recommend to you, I offer to you that going through a regulatory hearing, spending this meeting, another meeting, will not get us any more than we have right now. So yes, it is recommended.
Let's raise the motion. How shall we start? Was there another
I'd like to have-
commentator first?
Do you want me to summarize a motion?
Yes, we
please?
would like that, please.
Mr. Chairman, I'm interested in proceeding because look, we're going to get their money. They're going to have a rebate to our constituents. We're going to be provided with 10-day mail within 10 days notices regarding the full disclosure. I think what's left are semantics in terms of who's following whose regulations, and hopefully in 30 days we can work that out in terms of language that would be acceptable to both sides so that we can proceed.
We'll know by the second meeting of this small group whether or not we have consensus, and we'll report immediately.
I would just like 2 points of clarification, Terry. There's no rebate for anybody in here, so I don't think that language should be used. This is a fine. The fine will go to the commission. Information will be given to the public. I beg to differ that there isn't anything of substance here. This is a lot more than semantics. The company is adamant in their refusal to agree that we have any right to regulate unless they give their consent to each and every regulation. I do not see them backing down anywhere from here to that.
Number 5 in the letter says that.
I'm
If they
assuming
don't agree upon it, we're right back.
we'll be right back here on
And we're
December
not putting our
5th.
regulations up for grabs.
That's right.
No, I agree. These
We're not.
regulations are not up for grabs, and I think it's important that we say that and say that clearly for our constituents. That we, are just, I am diametrically opposed to the position of the company in that regard. I'd be opposed to their position on a national level. I'm opposed to it locally. I believe that we have responsibilities and that we will exercise those responsibilities reasonably. I think we have public hearings at which the cable industry has every right to come in and tell us what's wrong with the regulations we're proposing, but I claim that we have the right as elected officials then to make those reasonable choices between protecting our consumers and having a company say that we can't have any regulations unless they agree to them. So I think it's a lot more than semantics. It's at stake here today. And I do believe that if we do the settlement, and we will be back in a public hearing on December 5th on any of the proposals that would come out of negotiations between whatever process the company, our attorneys, our executive director in Orville, and the committee would take part in.
There are 2 members, at least, of our commission who have to be elsewhere at other meetings very, very shortly, and we need to accommodate them. There is going to be one announcement made after we finish this part. I hope some of you can stay for Randy Van Dalsen's jubilant announcement of a coming event. But now we are at the point where Brent is able to rise and report.
Can I list all of the points as I understand them in the proposal, and then because of the nature this is coming forward, I'd like to have Mr. Moorhead step to the microphone one more time and commit his clients, the initial franchisee, to each of the points as I state them, only when I've stated them all. If I haven't, we'll modify it. We'll do it accurately that way. I understand the proposal to settle this to be as follows. 1, the initial franchisee will concede the 3 allegations factually that have been made against them today as the basis of the hearing. They are, to wit, that they failed, neglected, and refused prior to June 7, 1991 to submit and file with the Commission their subscriber documents, that is, those documents to be executed by the subscriber. Number 2, that they failed, neglected, and refused to submit and file with the Commission prior to June 7, 1991 their complaint resolution procedure. Number 3, that they failed, neglected, and refused to provide all affected subscribers at least 30 days in advance of their recent rate increase of October 1 with a Commission-approved general rate and programming disclosure. That those 3 facts will be conceded and admitted for all purposes as to the Commission, but not as to third parties. Further, that the initial franchisee, I guess this is the second point, will concede the reasonableness of an imposition of monetary sanctions in the amount of $59,200 and agree to pay that sum within 30 days from this agreement. Number 3, that there will be no third-party use of any of the factual admissions of the franchisee. Number 4, that there be no legal concession of the franchisee's arguments as to preemption on any basis of the Commission's authority to enact regulations by reason of their entering into this agreement. Number 5, that there be no media campaign undertaken by the Commission either with these funds received by the franchisee or with the Commission's own funds during this period. Number 6, Sacramento Cable and the initial franchisee will provide an interim disclosure as approved by your executive director of all rates and services and fees to be mailed to all subscribers of the system within 10 days of the date of this meeting. Next in number, Sacramento Cable will rebate, effective back to September 1, 1991, remote control charges to any subscriber who now or has downgraded their remote control service since that date. In addition, Sacramento Cable and the initial franchisee will waive all downgrade fees for premium services if those downgrades occur prior to November 30, 1991, and that goes back, it doesn't say it in this letter, but that goes back to September 1 of 1991. That is, any downgrades occurring September 1 to December 1 will not be charged a downgrade fee. Next in number, the initial franchisee will meet with representatives of the commission to be designated by the chair to discuss and clarify, if possible, the concerns of the franchisee relative to the regulations, to see if agreement can be reached. That if agreement is reached on or before December 5, 1991, and the regulations are amended to conform to that agreement, the initial franchisee will agree to be bound by the terms of those regulations as agreed upon and enacted at that time, indefinitely, without restriction as to time. Next in number, that if that is agreed upon, there will be no further changes in those regulations for 2 years. If after that time the commission enacts additional regulations unilaterally, that is, without the agreement of the initial franchisee, both parties shall have all of their legal arguments as to the legal ability and capability of the commission to so do. Further, that this discussion period will extend from today's date to December 5, and that during that period, the commission will not, during that period nor thereafter, seek to impose penalties for violations of those regulations that occur during that period. Nothing in that agreement is to restrain the commission's ability to impose penalties for actions that occur during that period but accrue after that period. Moreover, I think that adequately states that point.
And that the company during that period will abide by the regulations.
That's right. That was the other point, that during that period they will abide by the regulations.
Two clarifications, if you would please, on two of the things that you said. In terms of the rebate, the remote control charges to any subscriber downgrading their remote control service, could you explain to me what that means for a subscriber?
If a subscriber is currently receiving or has at any time after September 1, 1991, purchased the use of a remote control device from the initial franchisee and decides at any time between September 1 and December 1 to cease that use, they will be rebated any charges imposed for any period of time after September 1.
Is there an amount to that?
I don't exactly even
It's
understand.
$3.50 a month, so it's a maximum of approximately $10.50 if they did it on the last conceivable day.
That would just be for new subscribers.
No, that's anyone.
So anyone that indicated they downgraded and didn't need their remote, but they still have to take it and turn it in before they can make a...
All they have to do is indicate during that window that they don't wish to continue to rent the remote service. If they do that, my understanding of this provision is that they will be rebated, they will be credited all charges imposed upon them after September 1. Obviously, charges before that will not be credited.
Okay, that is not their current policy. The current policy is to require a subscriber to bring it to either Pell Street or some other location, and that's the only reason I asked for clarification. I don't want to get into a bunch more trouble in terms of what we mean by this agreement. I have one other question.
No. Could I make an interruption? Okay. We need to move to vote within 2 minutes, or we're going to lose members.
Okay, well, if there's no clarification on what the agreement is, it's going to be pretty hard to vote.
Yeah.
The gist of that, if I may speak to it quickly, is that the turn-in policy has always been in effect, and that's not changed. this issue relates to an issue that we thought was important to the Commission with regard to the converter since descrambling and the remote. And they still have to comply with getting us the remote control back. But if they do it at any period during this time, they get this retroactive rebate. It's really the rebate that's the benefit to them, and we've gone quite far on. There is one other matter, and I think it came out the same, Mr. Blair, but the 90-day waiver of downgrade charge runs from August 26th, not from October 1st or September 1st, October 1st. That was the date of notification of rate increase, and then the 90 days would terminate on November 26th.
November 26th.
Well, you got November 30 in your letter.
I'll live with the November 30th. That's fine, just so it's running from August.
All right. So
clear, it runs from August 26th.
For clarity, the rebate for downgrades of premium services would apply to anyone giving notice to the company of downgrade between August 26th and November 30. Is that correct?
Rebate is just a waiver of the downgrade.
No downgrade fee imposed on anyone giving notice during that period. Is that correct?
That's correct.
All right.
Okay. The last question I have, just again, is that sticking point. No changes other than by agreement will occur to the regulations for 2 years.
May I speak to that quickly, Mr. Blair? We are willing to put that item into the negotiation between now and 12/5. That was really something that came from the discussion.
Not a part of the settlement.
I would be willing to say we'll deal with what happens there as part of this process. That's fine.
So that term is not part of this settlement proposal. It will be
it's left for negotiation.
Right. All right. That's then withdrawn from the proposal.
You've heard the elaborately stated series of ideas that now comprise a complex motion. Is there anyone who would offer this as the motion?
I will move it.
Second. It has been moved and seconded. Is there further discussion? No. All right. The clerk will please call the roll.
Broughton Johnson? Toby Johnson?
Yes.
Collins?
No.
Roby?
Aye.
Strang?
Aye.
Ferris? Castanis?
Aye.
Nay?
Aye.
Fletcher?
Aye. The motion prevails, and then we could say this brings to conclusion the hearing that was on the agenda at this time. And we reserve the right for further action, if so be after the 4th of September, I guess one would say. Now, before we close off this meeting, we do have item number 2, public opportunity to discuss matters not on this agenda, but within Commission jurisdiction. And before we go to that, I would like to ask this group to give me the authorization to proceed with negotiations, selecting members of the Commission to aid in this, as well, of course, the regular staff. Is there any objection to my assuming that authority?
I would so move and give the motion in order.
Yes, second.
Is there any discussion? Will those in favor please say aye?
Aye.
Is there any opposition? Say no. All right. I just inherited another job. That then concludes item number 1. We thank you, Mr. Ruckert and Mr. Moorhead, for your participation, and apparently that letter was the one item that was needed to coalesce this and bring it into a new kind of focus. So you'll be hearing from us very shortly to set up a time to discuss, and we'll work out those details through staff, okay? Okay, we'll move it fast for everybody's benefit. Randy Van Dalsen, please, to be followed by Janice Jackson and then Richard Hansett.
Randy Van Dalsen, Executive Director of Access Sacramento, and I have an announcement that I hope will not be very controversial. I think it can unite all of us with a lot of real joy. And that is that I'm here to publicly announce for the first time that Access Sacramento has been informed that its application to bring the 1994 annual convention of the National Federation of Local Cable Programmers has been accepted. which means that in a few years from now, a number of people from around the country and indeed the world will be coming to Sacramento to learn more about government, educational, and public use of cable television. And we have I have a lot of people to thank, and I'm not going to try it right here, but those of you who helped us get together the incredible full package of support letters are it was something that just blew away the board of directors. They'd never seen anything like that. And of course, for that decision, apparently the number one item of concern is the level and diversity of community support. We certainly showed them here. And again, we're going to have a big group here in Sacramento in 1994 to celebrate the local use of cable television. So thank you.
Congratulations, Randy.
Yes, congratulations, Randy. It was good, hard work on your part, too. And I think that if we can imagine that many people of all that talent coming on the community at one time, that's going to be great.
And you must like the work.
Thanks again. And also thank you to Sacramento Cable for their help in putting together this proposal with their support letter.
Jackson.
Well, it's good they got some thanks today, right?
State your name, please, for the record.
My name is Janice Jackson. Mr. Chairman, members of the commission, this is the first time I've ever been before a hearing. I'm not sure exactly if what I have to say is the right forum, especially this part of the hearing. First, I want to say that...
Do you want to pull that microphone down there?
First, I would like to say that that I was very surprised to see a letter addressed to me as part of your attachment in your agenda. I had no idea. I came down here because I was interested after receiving notice that there was going to be a hearing. And because of my negotiations with Sacramento Cable Television. And I never received this letter. It's dated September 20th, and it says received by Sacramento Cable TV September 7th, it looks like. I don't know. 27? Well, anyway. All I want to say is there are some problems and some clarifications I hope that you will take up in your negotiations having to do with the fees and regulations that I'm not sure if they were included in your labels of remotes and so forth. But when we have to turn in our remotes, I don't know how to take this remote off of my TV, or the box off of my TV and have my TV work and turn it in.
That's a big problem, I agree.
The lady across the street from me is 78 years old, and I'm not far from that. She's a widow, and so am I.
Janice, may I introduce you to Cindy Simonson, who, upon finishing speaking, will advise you thoroughly on how to be of help to you.
That's true, though. I think the point she's making, though, Orville, is when you downgrade, you are asked to disconnect the converter, to bring that converter in, and for many people who do not know then how to get the cable connected to their system, they've now told you, though I believe you have the right to keep that converter with no charge. You do not have to, you're not charged for the converter. You need to turn in that little remote thing that runs your converter, and that'll get the $350 charge off. And the converter
they didn't tell me, because when I asked to downgrade to basic, and they told me I had to pay $40 for that, I said, you can keep your cable. I am not going to pay another installation charge. I paid that last year. And now to pay it again because I want to downgrade to limited basic, which I might state, when I asked Sacramento Cable about their services, I was never told that they had limited basic. They never told me anything about it. They touted their basic and the other things that they have and the cost, and I paid everything for it. Now I'm not going to pay for another installation charge, which is not an installation charge, or for them to come out and take their equipment from my house. So when I said, okay, terminate my television, they came out and took their equipment without any charge. So I don't have my CNN, all right. So I don't have C-SPAN or anything like that, which I really would like to have, but they don't have my money. And I think that this commission, which I was very glad to know existed and which I didn't know before I heard about your notice in Sacramento Bee, is a good one and a necessary one for those of us who cannot handle dealing with these monopolies or these companies and so forth. But I do wish you would think about the elderly people who have limited income and cannot pay these high fees. We cannot pay them. And I'm not going to pay $23 a month just to look at CNN. I think they have a monopoly almost on the service, on the international service and on the government things that happen, and we would like to see it too. We can't get C-SPAN, and I think that we should have the access to C-SPAN. Why should Sacramento Cable have it totally, and then we have to pay all this money to see it? Everything is too high, and I think you should be able to do something about it. I don't know if you can, but I'm just not going to pay my money for it if I have to suffer. And I do appreciate your letting me kind of say something about it. I hadn't expected this, I will say. Okay.
Thank you very much. I think one of the important things too for Janice, for you to recognize is that you do have the ability to write your congressional delegation and express your displeasure at local government not having an ability to regulate in any of these areas and how you feel about that. We simply do not have the ability to regulate either rates or how they switch around things on the tiers. I think most of us remember what it was like when they came into this community and told us all the wonderful services that would be on limited basic, which at that time I think was 25 cents. And they charged a hookup fee, but it was a reasonable fee. But we cannot regulate then when they change the things that people really wanted on and thought they were getting on limited basic, and when they bump it up to something else. We don't have any powers in that area. So that's something you should take up with the people who represent you at the federal level. Sorry.
Richard Hanseth.
Thank you very much. My name is Richard Hanseth. I live at 2428 Connie Drive, Sacramento. Mr. Chairman and members of the Commission, I've been a customer of Sacramento Cable since August 5 of 1991 after switching from their competitors, Pacific West. Since that time, I've had a constant problem with Sacramento Cable. They have been to my house over 7 times. Last night, they were there on each of these 7 times. I was told it was my equipment. I have brand new equipment. MGA, Sony, Zenith, top of the line. I could not believe that. I am a broadcast engineer by trade. I specialize in AM and FM radio, not cable television, however. Last night, a cable technician by the name of Steve Sisk was over at my house approximately 95 minutes. Could not find a problem. He did acknowledge the problem being Sacramento Cable. I was a victim of their gold package assassination on the market for $29.95. I have my cable TV bill here, and now it shows about $80 that I own because they raised my rates without notifying me. I have a contract here, which I'll be happy to provide you with a copy of. If you'd like to go into the technical requirements of my television set or sets and their output signal, I'd be happy to give you those numbers today. I am prepared. However, their meter, when I asked them when their meter was last calibrated, and when it was last calibrated back to NBS, National Bureau of Standards, they said it was simply a new meter, and it did not need calibrated. Any new meter needs to be calibrated according to the Federal Communications Commission. And I think they need to deliver a quality signal to my house for any price. They have been to my house. We've already discussed the $5 disconnect premium fees. What recompense do I have as a consumer for a snowy grainy picture at $80 a month. Do I have to have them live in my house? I don't want that. I don't have room for them. They said they take care of the customers, according to Mr. Moorhead. They've certainly been over my house enough times, but they haven't taken care of me. They still send me a bill. I still send them money. What can I do? That's why I'm here. Thank you.
Thank you.
Should that be a complaint that gets filed with our engineers? Or how do we?
Vicky?
Yes.
Yeah, could you give all of that information to our
I have bits and pieces.
The technical information?
Yeah.
Actually, I recommend this. Based on your appearance here today, I think we ought to give Sacramento Cable another day or two to see what's going on.
They had the supervisor supposed to be out at my house at 1 o'clock today.
Mr. Ruckert is an engineer. He may be able to help you.
Okay.
But yes, these are the type of complaints that don't occur very frequently.
Yeah,
but when they do occur, we bring in our outside independent engineers. We schedule tests randomly in a particular zone without notifying Sacramento Cable, and they present us with an independent report.
I have one of my television sets being taken currently to Audio Lab Electronics, a local consulting engineering firm, to make sure it meets the input requirements. The other one I know it does. It's brand new, but I see this on 3TV.
This is a very unusual problem to come up in relationship to the franchisees, so it's something that we really need to get to the bottom of.
Do I have to pay these people?
That's something I think you better take up with them. If you're not getting a service, I would not like to pay for a service.
I asked their installer last night. I said, "Is it my TV? Is it my VCR?" He said, "No."
Mr. Hanseth, we must move to the next one, but we arranged a very elaborate meeting today just so you and Mr. Ruckert can get together.
Thank you. I appreciate it.
We seldom do this, but we'll have our last presenter, Vicky Korsak, please.
Hi. I'm Vicki Korsak. I live in Citrus Heights. And I had the limited basic service over a year ago.
A little louder, please. Pull the mic toward you.
Okay, is that better? I had the limited basic service over a year ago. I paid the $40 installation. They came and put a hole in my wall. And within about 9 months after getting it, they advised me that this 25 cents a month service was going to go to $5 a month, and then at a later date would go to $10 a month. And I read the back of my agreement when I installed it, and it did say that they were entitled to increase. Without notice, they'll notify us and they'll increase it. But first of all, I think that was a bait and switch tactic. I paid $40 and then boom, I don't think that was a fair and reasonable increase. I think there should be some kind of regulation for fair and reasonable increases. I think competition should be allowed to come in to this area, because I did feel like I was very angered. I was very upset with what had happened. I felt they were criminals, and the way they handled it, I called, I tried to speak to people. They were very rude. They didn't return my calls. I wrote my congressman, and Matsui did, send the letter off to Washington to the commission out there, and I got a lot of response from him, and I was happy with that. But I just, for the people here, the poor people or whatever, they have a right. I don't think their rates are reasonable. I believe in companies getting fair and reasonable profits. My job, my trade is a contract negotiator for the federal government at McClellan Air Force Base. They are not fair and reasonable in their pricing and what they're doing to the people. And if they're not going to be, I would like to see more competition. I was on a trial recently. I was a jury on a trial, and the bailiff of this trial used to work for Sacramento Cable, he told me. He told me that he didn't like the company. He left them. One of the policies they did is they heard competition was moving in, so they went around to neighborhoods, offered people free hookups and a month free service, so when the other company came around to say, can we offer you our services, they would say, well, I already got it. I've got free hookup and free service. I don't like that practice. That is illegal. That is wrong. I don't like what is happening. Regulation needs to be, competition needs to be. I don't like to be a victim. And I don't like other people seeing other people become victims. There are a lot of people this affects. And I would like to see it opened up for competition to bring them down. I don't like to see tactics like this happen, and that's why I came today. That's all.
Thank you very much.
The last 2 hours have been to address those issues entirely. That's what the last 2 hours have been about, those
I think the
regulations.
difficulty that you find in trying to get head-to-head competition, though, over the whole system is one that's endemic to the whole industry throughout the United States. And that's why I do feel that the cable industry, by their own tactics, will eventually invite stronger and stronger regulation, because I don't think consumers will stand very long for unregulated monopolies that are created by business practices more than any other factor. I'd like to read into the record a little bit a concern that was expressed by a member of the deaf community. Did you all get that letter? I don't know whether the people who are hearing impaired have really sent this as a whole group to the cable company, Kim, but one of the things the person brings up is that so little on cable is for the hearing impaired. It does not have the closed captioning. And so they bring up concerns about the rate at which they're charged in order to get just those programs that are closed captioned. I don't know of any remedy right now, but I think this is something you might want to take a look at and perhaps propose some things to that community that is hearing impaired and yet does want to be kept abreast of affairs.
Thank you. Is there any other comments?
No other comments.
Then I declare this meeting adjourned. Thank you for coming. We'll have good news on the 5th of December.
Sure. Good luck, Corbin.
I thought it was going to be November.
It may be.
Well, they have until the 5th, and that's